The Supreme Court today, you know, I keep telling you, we have a constitutional monarchy here in the United States. We no longer have a representative democracy or a democratic republic. We have a constitutional monarchy. There are 9 people who sit in a building about 3 blocks from where I am sitting right now who decide ultimately what the laws of this land are or are not, and in many cases actually even make up laws out of whole cloth. Great example of that being Roe v. Wade, the doctrine of fetal viability, for example. Now, I'm, again, neither speaking for or against it, simply pointing it out. Another one, 2010, well, actually, this was a long time, much longer time in the making than Roe v. Wade was. Citizens United saying corporations are people and money is speech. I mean, these are things that literally came out of the imagination of the Supreme Court. And frankly, in my opinion, they have no right to imagine. It is not in the Constitution. But that's a whole nother rant. Today, the Supreme Court got together and heard arguments. Today, it was in Prop 8 in California, which the Mormon Church and Mitt Romney's buddies spent a fortune to get passed to ban gay marriage in that state. And after the state had adopted gay marriage, as I recall, or at least some communities had, San Francisco had. And tomorrow they're going to hear the decision on, or they're going to hear arguments on the Defense of Marriage Act, DOMA. And Farnan, the associate producer of our program, is also the Supreme Court reporter for the Talk Radio News Service, as well as an attorney, or a law school graduate, a guy who knows this stuff far better than I do. Hey, Shano.
I know it somewhat, and what you were speaking about right there, Justice Scalia actually articulated that today about the Supreme Court deciding what the law is. I have it right here.
Really?
Check this out.
We decide what the law is. I'm curious, when
we decide what the law is.
Yeah.
Actually, it starts a little bit before that. I'm trying to find the clip.
prescribed law for the future,
you know, ever since 1803, Marbury versus Madison, really they didn't start asserting this right and using it until after Dred Scott in 1856. But, you know, the Supreme Court has been saying that they're the kings. Mm-hmm. So in any case, back to Prop 8. What were the arguments today, Shano?
Well, the arguments today were twofold. First, you know, we have the merits of the case, which everyone knows those arguments. What was really interesting is that there was a standing issue here that hasn't got as much coverage.
Now, explain what standing is.
Standing is, can you bring the case? Are you the proper person to bring it?
Right.
And under Article 3 of the Constitution, there has to be a case in controversy. So in order to say, court, I want you to hear my case, you actually have to be injured. All right.
In other words, I can't go into court and say, my friend down the street got hit by a car, and so I'm going to sue for $1 million on behalf of him, and just keep the money if I get it. The court would say, no, he can sue, but you can't.
Even further, you can't just go in and say, I don't like this law. I really hate this law. It's called a general grievance.
Right. You got to say, I don't like this law because
it affects me.
It's causing my left leg to fall off.
Exactly.
Right.
Now, the original case was filed by 2 gay couples that wanted to get married.
Right.
They won. So then the question
was, clearly had standing, by the way, because they were affected.
Because they were affected. But then, as they won, then you want to go to the appeal. So who appeals it? The original case was brought by those couples against the governor of the state of California.
Who was Schwarzenegger, who was opposed to gay marriage, so he fought it.
But then it was Brown.
But Jerry Brown is not opposed to gay marriage, and so he says,
I'm not going to.
Yeah.
So there was no one to appeal it. It would normally be the governor or the attorney general. They both declined to defend Proposition 8 on its merits. So the judge allowed the people who put up Prop 8, the Mormon Church and those types of groups,
a collection of right-wing fringe groups,
to
whatever,
appeal. And the thing is that they had to also prove that they had standing because they were bringing the appeal.
Right.
The Ninth Circuit said, yes, you do.
Under what rationale?
There is a California case law that people who bring initiatives have standing to defend those initiatives. It's through a court doctrine, essentially. But the thing is that's a California law. And the issue before the Supreme Court is, can California law dictate to us, the federal courts, what our jurisdiction is?
Okay.
And a lot of the judges...
So these guys arguably had standing in California because it was their proposition that got knocked down, but there's no federal law that says...
There's no federal court jurisdiction, so they didn't even have standing to go before the Ninth Circuit, because that's a federal court, and federal courts determine their own jurisdiction. They can go to state court all day.
But the Ninth Circuit still knocked it down, didn't it?
The Ninth Circuit
knocked down Prop 8.
Knocked it down on narrower grounds. But arguably, they didn't really even have standing to do that. So,
according to this argument that was placed before the Supreme Court today.
that a lot of the justices seem to agree with. Certainly they had concerns. At one point, Justice Kennedy said, this is a serious jurisdictional issue
Right.
that has a lot of credence to it. Because Justice Sotomayor said, people, you may have an interest in defending this, but you're representing the state of California, and you don't have fiduciary duties to the state of California. You're representing your own interests, not the interests of the citizens of the state.
Right.
Like
So
a
what are you
governor
doing in
would.
front of us?
What are you doing here? Because those are your interests. Breyer said there's a difference between defending this law and defending the law, which I
Right.
thought was pretty profound.
Yeah.
So it's quite possible this case could be, they could simply say, if they don't want to wade into this and determine rights at this point,
And get involved in states, basically get involved in the 10th Amendment issue.
exactly.
Then all they have to do is say, this isn't ours. It goes back to the Ninth Circuit, which has already said Prop 8 is unconstitutional in California, and so Prop 8 dies.
It actually would go further, probably, because they would say to the Ninth Circuit, you didn't have jurisdiction to make your ruling.
Okay, so then it goes to the state Supreme Court,
Goes
which...
goes to the federal district court in the state of California. It's a federal district court, the lowest
Okay.
federal court in California.
But that's still a federal court. Do they have...
And they decided that it was unconstitutional on due process and equal protection under the 14th Amendment, and that would stand.
But are you sure that, because that's a federal court, I mean, shouldn't it go to a state court?
No, because the federal court did have jurisdiction, as we said. The same-sex couples who wanted to get married, they had standing to bring their original case. It was the appeal where there wasn't any standing. The Supreme Court said you must have.
So
standing
this was
to
when
appeal.
Schwarzenegger was
Sure.
fighting the game.
And when it
Either
comes,
way,
when it comes to
Prop
standing,
8 gets knocked down.
right? Yeah, exactly. And standing doesn't actually deal with the defendants. It's whether the person bringing or the
Right.
group bringing the actual case.
Right. Now, all that said, I mean, I understand that there's also a way that the court could deny standing, and in doing so could basically say, and by the way, Medicare, Social Security, Medicaid are all unconstitutional. Are you familiar with that argument?
I've read a little bit about this.
Did you hear
probably know
anything
more.
this morning that indicated to you that anybody might be going down that road?
No.
I figured that was more of the kind of...
That was alarmist, tenthers,
Right.
hopeful,
Right.
wishful thinking. I
Right.
believe.
Now you also, when we were talking off the air, you said that Justice Kennedy said something particularly interesting. This is
did.
a swing vote. He's a Republican nominee and typically votes with the other four right-wing crazies.
Right.
But he's not a right-wing crazy
No.
fully. He's, or at least
he likes being
didn't
the most,
used to be.
He likes being the most popular justice, that's for sure. But there was a line of questions. They were at first talking about what the harm to marriage is if you allow same-sex couples to marry.
Right.
Justice Kagan then turned it around and said, well, what's the harm if you do? Who's going to be harmed? And Justice Scalia piped in saying, well, it's going to hurt adopted kids. But then Justice Kennedy, and essentially what it came down to is they couldn't figure out, and this was for Mr. Cooper, who was a proponent of Prop 8, saying any of these damages, any of these things, we don't really know yet because this is really new and, 10, 20, 30 years in the future, there could be all these devastating results, but we really don't know. And Justice Kennedy came in and said, but there is a damage to not allowing this to happen.
Here's the clip.
On the other hand, there is an immediate legal injury or legal, what could be a legal injury, and that's the voice of these children. There are some 40,000 children in California, according to the Red Brief, that live with same-sex parents. And they want their parents to have full recognition and full status.